afternoon, good evening. We are just waiting to see if we are going to be able to get into this hearing regarding Lori Vallow. As everyone knows, the last time we were in court, hi Jim Cat. The last time this was in court is when the judge had came across the order and made that public about Mark Means being removed from Lori Vallow's case. This is going to be interesting because Jim Rubillard, whatever his last name is, that new lawyer she's got, was supposed to go and see her and let her know about this and discuss this with her. So I'm anxious to hear what's going to happen. Hello, Yum Diddley, Georgia, Cindy, Jumcat, Sherry. Hello, everybody. Yes, I'm doing very well. Thank you. So I am in one area where I'm hoping that we can get in to see this. And if it is going to be streamed, then I will be able to stream it for you guys. Hello, sweet Sherry, Lorna, Alicia, Shannon. Hello, everybody. Please smash that like button on your way in. Let people know that we are live. The more likes that get smashed there, it gets it out into the algorithm. So you can just click off the chat, click on like, and then come right back into the chat. And you guys, please click live chat at the top. Hello, Bonnie. Sammy, thank you for joining. Make sure you have live chat clicked on the top instead of top chat. Hello, Cindy. Bonnie Baker, hello. Hello, everybody. Oh, you're very welcome. I'm just hoping that this, you're going to be able to see it. We were able to see the last one. I could bring you that one, and we did watch it. Not much happened because it came out that Mark Means was removed from the case. I'm also watching the Barry Morphew one, you guys, for the next hearing on that one after the judge was removed from the case. So I'm still waiting on an update for that one too. And it's supposed to start any minute. So I am refreshing. So if you do hear me clicking, that is me refreshing. Hello, Vicky. Hello, everybody coming in. Yes, 23 likes and 34 people in chat. Please smash that like button. Hello, Country Girl Life. Welcome. Thank you for joining. Hi, Debs. Kayla, hello. Please smash that like button on the way in, you guys. Let everybody know that we are live. It helps with the algorithm. Hello, Janaka, Susan, hello. It is supposed to be starting any minute. On the trail, Kim, hello, and welcome. We are hoping that we get in. I am here and waiting, so I hope that I am allowed into this so I can bring it all to you. They always run a minute or so late, so a couple minutes late, sometimes 5-10 minutes. Hello, Kat. Welcome, everybody. Let's hope that we can see that. Thank you, sweet Sherry. Thank you. Yes, please smash that like button, you guys. So it lets everybody know. We got 34 likes and 42 people in here. Please smash that like. Let everybody know that we are live. You're very welcome. Thank you for being here. I'm just hoping, you guys, that this is going to be streamed. I am in the room waiting. I'm anxious to find out, like probably all you guys are. Hello, Georgia. He was removed because he is friends with a lawyer from the firm that is representing Shoshana Dark, whatever her name is. Keta, hello. Apparently they've been friends for like 40 years, and there's a conflict of interest because he's known one of the lawyers in the law firm that Shoshana Darkey retained Her charges have all been thrown out. But let's see what happens here, you guys. Janice Vander, hello. Suzanne. DJ Cook, hello, hello. Sweet Sherry, hello. So far, nothing, you guys. But like I said, sometimes they are late, so I'm just hoping that they are going to allow everybody to see this. It should be open court. It should be available to the public, but we're just going to have to wait and see here. Yes, Vicky H. Mark Means is gone. The last time that we were in the court proceedings here, the lawyer that she has, Jim Robillard, asked that he be able to go and speak with her because he doesn't know if she knows that Mark Means has been thrown off the case. And also, the prosecution has a motion that they want heard also, that to stop Mark Means from talking about the case or meeting with Lori. So Shoshana, yeah, that's the one that's a totally different case. Has nothing to do with this one, you guys. That's the Morphew case, which I am watching also because the judge has been removed from that case. So we got a lawyer removed from this case. We got a judge removed from the Morphew case. Hello, Manic Mama, and welcome. Well, welcome. We're glad that you're here. So we are waiting to see. As soon as this starts, I will share my screen. Like I said, for those of you just coming in, excuse me, the prosecution has also filed a motion regarding the Vallow case to stop Mark Means from speaking about the case anywhere because there is confidential information that he would have that he could spread, which is, would not be good. We don't know if Lori is going to make a physical appearance, Janaka. We'll have to wait and see. I think it's going to be really funny how quick she is going to become competent when she finds out that Mark Means is no longer representing her, and the only way she can fight this is to be competent to be able to fight it, right? You can't fight something if you're incompetent. So I'm kind of wondering if this is all of a sudden going to make her competent, if she's going to stop playing her game once her prized lawyer is now gone. Like I said, the only way that she could even try and fight this is if she was competent to do so. So I'm anxious, like you guys are, to see this hearing today. Also, the prosecution wants sanctions against Mark Means, and also they want to put a gag order on him so he cannot share any information that's confidential, client privilege, even though he's no longer her lawyer. You never know. He's a loose cannon, right? Yeah, like I said, lawyer gone from this one. Thank you, Debs, for becoming a member. Lawyer gone from this one. The judge being disqualified in the Morphew case. There goes her Jim Cat. I love it. Yeah, there goes her sixth husband. Who knows? And apparently Mark Means has moved out of Idaho now, too. So, I mean, he's been disgraced. So, again, thank you, Debs, for becoming a member. I appreciate that. Yeah, I'm waiting for that, Vicky H, for Lori to all of a sudden become competent so she can fight this. All right. So let's see what's going to happen. I keep refreshing you guys to make sure we're not missing this. I just hope that this isn't under seal. I haven't read anywhere that it's under seal, so we should be able to see it. And like we know, they're always running behind. So we're going to give it about 15, 20 minutes and see. This is supposed to start at 3 p.m. their time, so that's 5 p.m. my time. And here we go with the sex. Yeah, you can just piss off. I'm not sure, Georgina, if Mark Means was LDS or not. I don't know. I'm going to ask the mods, please watch for them. I just hid Beppa. They're putting that fun.fyl, those sex sites up again. So we got a lot of trolls in here. Please watch for that. And block them from the channel, hide them from the channel, whatever you got to do. And remove the comment. Yes, I am anxious to see this too. So let's hope, you guys, that I can get in this. Let me just check, you guys. I won't be able to see chat for a minute. I just want to go over to chat to another place here and see if anybody else is covering this right now. Like I said, I didn't see anything saying that it was under seal. So let's hope that they are just running late. Yes, me too, Keta. I hope this year is a lot better than last year. Capel says, oh, my dear Willow. Yes, I hope everybody, too, is having a great 2022 so far. It's no, the case isn't on its third judge. Judge Boyce has been on it since they were filed, but because Eden's was in another district than the case that where it is now, and the other judge was for Lori Vallow that she had while she was in Hawaii when she was fighting deportation. That was the female judge. So Judge Boyce has been on this since the beginning. Okay, here we go, you guys. I'm going to start sharing my screen.
Please put one in the chat if you can hear it.
Noreen Vallow, aka Noreen Daybell. This is the time we have scheduled for a hearing. The state filed a motion
Please
to
press
modify,
one if you can hear it.
or in the alternative, to extend the court's protective order.
Thank you.
And for starters, I'll indicate there was a protective order issued in this case, and it was filed under seal, and that was issued on July 15th, 2021. Courts reviewed the contents of that order, and pursuant to Idaho Court Administrative Rule 32I, the court does find that for purposes of this hearing, counsel may refer to and mention the order or the contents of that order, even though it's under seal. The court will make a determination that won't violate the terms of the order sealing the protective order, as it's the subject of today's proceeding. If we need to go into any of the specific details or allegations that led to the issuance of a protective order, the court would ask that that be done in camera, on the record, but outside of the public view in a closed portion of the proceedings if necessary. Appearing today for the state is Lindsay Blake, who will be arguing the motion. On behalf of the defendant is Mr. Archibald, And I understand, Mr. Archibald, your client is listening in telephonically to this hearing. Is that correct?
Yes, Your Honor.
Okay, thank you. We are conducting this hearing by Zoom remotely. It's also being live streamed on the court's YouTube channel for public access to the hearing. And so I will bring up another part of this motion. It was filed on shortened notice on December 29th, and so we're having a hearing on shortened time frame. I wanted to ask Mr. Archibald if you object to the proceedings going forward today on shortened time as requested by the state.
Your Honor, when they asked if I would be okay with setting this within the time frame, I said yes, that's okay to set it quickly. I still do intend to object to the contents of the motion, but I'm okay with proceeding.
Very well then, on the motion for request to shorten time, the court will grant that and we will proceed forward with the substance of the hearing then today. So the state's filed the motion, the court's reviewed that. I understand Mr. Archibald has an objection to the motion. So Ms. Blake, if you'd like to offer argument in support of your motion, you may.
Thank you, Your Honor. The state did file a motion to clarify or in the alternative to extend the court's protective order, which was put in place pursuant to Idaho Rules of Criminal Procedure, Rule 16 specifically, and specifically subsection L. The state had previously filed a request or a motion for a protective order to be put in place with regard to the discovery in this case. There was later a hearing regarding that motion with regard to the case number applicable to Chad Daybell. That order was essentially modified with regard to that case number. However, it's the state's understanding that the order, that protective order, remained in place specifically with regard to Mr. Means in Ms. Vallow's case. That motion was supported by a sealed declaration or affidavit under Idaho Criminal Rule 16L or Rules of Criminal Procedure 16L. The requirement is that that declaration remains sealed if the protective order is granted. So the state did not intend to get into the details of that declaration today, specifically because it is sealed and has not been provided publicly or to counsel at this point. It's the state's understanding that this court had reviewed that in making the determination to keep the protective order in place with regard to Mr. Means. It's the state's position that this court has broad discretion when determining issues with regard to discovery and whether or not there should be a protective order in place to protect the integrity and the fairness of all parties or the right of all parties to a fair trial. The state's position is that that authority of the court over the discovery, the protective order, and or potential dissemination of those discovery materials remains within the court's purview and control, whether or not counsel is active in the case. So the state had initially, this is a two-part motion the way it's drafted, because it would be the state's position that that protective order actually is still in place, and we simply wanted to clarify that. And specifically with the additional hearings that happened with regard to the protective order, it's specifically in place with regard to Mr. Means. The state's position is it does not matter whether or not he remains counsel of record, that the court maintains discretion and control over that protective order. And we would just ask to have that clarified. If in the alternative, the court does not view that as currently being in place, then we would be asking the court to consider expanding or extending that order, continuing forward. In addition to that, the state would note, and the court is probably aware, there have been certain discovery materials that have been disseminated or disclosed that relate to this matter. They were not disclosed specifically here in Idaho, but have been disclosed in other jurisdictions or in another jurisdiction. However, it is still the state's position that given the voluminous amount of discovery in this case, there is still a significant amount of discovery materials that have not been disclosed or disseminated to the public. and that it would not be in the interests of any party's right to a fair trial if those were to be disclosed. Specifically, there are some very sensitive documents that have not been disclosed. Again, based on the protective order being in place, the state did not intend to specifically list any documents. If the court felt that it was necessary or important for the court to know what some of those documents are, I think the state would request to discuss that in chambers and then make a determination whether or not the court wants that placed on the record. But that would be the state's position with regard to that. I think in addition to that, Mr. Means has an ongoing obligation based on the court's recent order with regard to removal of Mr. Means from this case. There was a finding that he had represented both Chad Daybell and Lori Vallow Daybell. So it's the state's position that he has an ongoing ethical obligation as well to both of his former clients under Rule 1.9. And we think the court can take that into account as well in determining the appropriateness of continuing forward with this protective order to ensure the integrity of this case and the rights of everyone to a fair trial. In addition to that, with the court's most recent order and some of the issues or concerns that were addressed in that order, and the state recognizes some of the state shared in those same concerns and had raised a lot of them in response to some motions filed by Mr. Means. But specifically what the state is referencing or looking at is the concern regarding Mr. Means filing documents under penalty of perjury and documents that specifically referenced or at least alluded to conversations he may have had or did have with his client, Ms. Vallow Daybell. The state has concerns, shares the court's concerns regarding those and the potential for Mr. Means to become a witness in the case. So we would ask the court to consider looking at Rule 1.9, and the court had previously referenced 1.7 in the court's prior order, whether or not some kind of an additional order prohibiting or restricting disclosure of any conversations he may have had with Ms. Vallow Daybell and or discussion of the most recent pleadings that had been filed where that was referenced. The state believes it may be prudent for the court to look at entering some kind of an additional order. We wanted to raise that concern and leave it in the discretion of the court. The state does not believe anything has changed with regard to the protective order and the need for the protective order or the potential negative ramifications and implications if that order is lifted with regard to Mr. Means.
Let me ask a question here, Ms. Blake. The protective order, in effect, relates specifically to documents in discovery and information in the case. I guess the concern I have is what's being raised here to me seems like you're asking for what I would consider a gag order, where in your motion is requesting that I order that he be prevented from public comment, for example, and as you just mentioned, from essentially talking about the case, which to me, that's a request for a gag order, which is certainly different than the order that's in effect that only relates to discovery in the case. So is the state asking for a gag order here?
We are not, Your Honor, and I guess I should be clear on that, and maybe I'll clarify that a little bit better. We are asking that the court clarify whether or not the current protective order that has been granted specifically is currently in place with regard to Mr. Means that is applicable under Rule 16L. We're asking for clarification that that remain in effect. If the court did not see it as remaining in effect right now, we would be asking to expand or extend that order to continue to remain in place with regard specifically to Mr. Means based on the attached declaration that was filed with the state's motion and the rationale provided in there. And then so that was kind of a two-part argument. And then the third part, and I think I called it a two-part argument, but the third part would be the state just wanted to essentially address our concerns and join in the concerns addressed by this court in the most recent order regarding those communications. We are not specifically asking for a gag order. we wanted to raise the concerns that the state had, and then leave it in discretion of the court whether or not any kind of an additional order is appropriate. I think in our motion, we'd also specifically outlined the state is not asking for a gag order, generally speaking, because we have indicated in our motion, and it would be our position, that we do think if at any point the court ordered or the court authorized Mr. Means to talk about any of the discovery materials under the protective order that was put in place under Rule 16L, and or if the court did create any other kind of an order restricting Mr. Means' comment regarding conversations he's had with his client, that would still be in the court's discretion to allow those comments to occur. The state is not trying to become the micromanager of those. We just had concerns and felt it was more appropriate if the court and or current counsel, Mr. Archibald, if one or both of your permission were required for any kind of disclosure regarding the discovery materials, and then separately, if the court does enter any additional order regarding restriction of conversations, that then the authorization be required from the court and or Mr. Archibald for those to be made public, or for public comment to be made regarding those matters.
Okay, well, thanks for your clarification on that point. Mr. Archibald, what is your response to the state's request?
Your Honor, I was not involved in the case when the initial protective order was put in place by Judge Watkins in July of 2021. I've seen the order. I don't know the reasons for that. I know there are rules of disclosure of grand jury transcripts, particularly Rule 6.2 of the Idaho Criminal Rules. So I have received the grand jury transcript. My client has not seen it. I intend to make a copy of it for her, and so that she knows what the evidence was that indicted her on these charges. But reading the protective order by disclosing the grand jury transcript and discovery information to her, that could potentially be a violation of this order. And so I certainly don't think the court can impede in my ability to get discovery materials to my client. And the reason that could be a violation is because they won't be in her possession. She can read them, and then because she's at the state mental hospital, then she would have to turn those over to the custodians there, and then they would safekeep them for her. So in that respect, this protective order is complicated in that other people will take possession of these materials for my client. I'm objecting to this modification of the protective order, in part due to they're mostly asking for prohibitions on Mr. Means. And Mr. Means, as former counsel, was not served with a copy of this motion, was not notified of this hearing by personal service. He's not a party to the case anymore. And so, yes, he knows about the state seeking additional restrictions on him, but it is unfair for the court to put an order on him when he's not a party to the case. Attorneys owe their clients duties, both current clients and former clients. They owe them duty of loyalty, a duty of confidentiality, and all of us attorneys have those duties to our clients, whether they're current clients or former clients. And so Mr. Means is still under obligations to Lori Vallow to be loyal to her and to keep her secrets confidential. And he knows of those duties, and he should respect those. And so in proceeding with this hearing today, to clarify this protective order, it would be improper, I believe, for the court to issue orders impacting Mr. Means when he's not part of this hearing. The information in this case is voluminous. I agree with the state. There has been so much information produced by who? By Lori Vallow or her attorney? No, it's been disseminated to the public by law enforcement, by both Idaho law enforcement, by Arizona law enforcement, by Utah. And the court knows about that. The court knows about that because of the change of venue hearing. The court has been able to see all the media publicity about the case. And did that information come from the defense? No, it came from the state or other state jurisdictions. And so to continually try to ramp down on the defense as though we're doing something wrong is, I believe, misguided. But because the court has heard the change of venue evidence, the court has ruled on that. Court has transferred venue because of that. And so any further restrictions on defense of dissemination of information, I believe is not justified. And so there haven't been any violations, I don't believe, of this order since July. And so for the past 6 months, this order has been complied with. So I don't see the point in making further restrictions on the defense. That it's been abided by. There haven't been any motions for contempt or sanctions against Mr. Means or the defense. So I don't believe this motion is well taken. So for those reasons, Your Honor, I object.
Okay, thank you, Mr. Archibald. Ms. Blake, anything you'd like to say in response and rebuttal?
Yes, Your Honor, and I'll try to keep this brief. As the state indicated, when we filed this protective order, or I guess we didn't make this clear, when the motion for the protective order was filed, it's the state's recollection that Mr. Archibald was not counsel of record at that time. As I indicated, there was a hearing held regarding the state's request for the protective order, and essentially the state's understanding and interpretation was the order remained applicable to Mr. Means based on the sealed declaration that was attached to the state's motion. The state does recognize that Mr. Means was not served and a copy of the state's initial motion for the protective order or the declaration, but that was done pursuant to the requirements of Idaho Criminal Rule 16L. It specifically indicates it's an ex parte motion and that the declaration will remain sealed if it is granted. So the state also recognizes that Mr. Archibald has not had an opportunity to review or see that declaration. The state's position on that is we are simply complying with Rule 16L. If the court believes that it has discretion or authority and Mr. Archibald needs to review that, the state would leave that solely in the discretion of the court. The states, additionally, we want to make clear we're not asking for additional restrictions under Idaho Criminal Rule 16. We are only asking to have that remain in effect, whether or not that's just clarifying that it does remain in effect or whether or not it needed to be extended or expanded to remain in effect, but we're not asking for additional restrictions outside of what are already in place with regard to the disclosure of any discovery materials or information. Further, the state does not believe at this point that that protective order has been made applicable to Mr. Archibald or that he is bound or restricted under that. I think that would require some additional findings or restrictions to be put in place by the court, and the state is not asking for that at this time. Again, it's a situation where the state's rationale and reasoning is provided in a sealed declaration that we are not getting into the contents of today. So we reference back to that with regard to why the state had requested that. And I believe that was the rationale for the court keeping that in place at this point in time, or it initially being granted by Judge Watkins. The only additional concerns raised by the state today are based on some argument made by the state previously, the court's most recent order removing Mr. Means from the case, And the state wants to make clear, we're not specifically asking for additional orders. We simply wanted to address that the state shared the same concerns and wondered whether or not the court felt an order would be appropriate and wanted to raise that potential concern there. But we're not specifically asking for any specific order, just raising that as a potential concern. And if I can have just a moment, Your Honor.
Yes.
And that's it for the state, Your Honor. Thank you.
All right, thank you, Ms. Blake. Well, the court's reviewed the motion, which, as has been mentioned, was prayed for in the alternative. I've reviewed also the order, which was issued by Judge Watkins on July 15th, and looked at the terms of that order. The order, as it's written, I think serves to be in effect as to both Mr. Archibald and Mr. Means as written, and because of the broad language of the way the order was written, I'll just cite to the first one of the sentences in there. It is ordered that no one having access to the discovery in this matter, including but not limited to the state, the defendants counsel, employees, etc. So I think the terms of this order cover both current and former counsel for the defendant, wherein obviously Mr. Archibald is currently defendant's counsel. Mr. Means is prior counsel, but he is still someone that is included but not limited to, if we use that language, someone who has access to the discovery in the case. And so I don't see a reason to need to expand the order. And my concern I had, as mentioned, was whether the state was seeking some sort of a gag order against Mr. Means. And if that were the case, then Mr. Archibald's arguments about him requiring notice of any such proceedings and an opportunity to be heard would come into effect. So the court will simply grant the motion clarifying that based on the language of the existing order, the order does not need to be modified or amended, but the language includes the restrictions as they apply both to Mr. Archibald and Mr. Means, and that order continues in effect in the case. With that being said, Ms. Blake, there was a concern raised that perhaps the order was in fact too broad, and Mr. Pryor raised that in his case, in Mr. Daybell's case, that the way the order was written, it appeared potentially he couldn't even have office staff and others having access to the information to assist him with the case. So I recall that issue coming up. I don't recall that we modified the order in that other case. And if you'd like to clarify that, I think the order is clear that discovering this case is not to be disseminated outside of the attorneys working on the case and those necessary to assist them. But it doesn't need to be so broad that, for example, if Mr. Archibald has an assistant helping transcribe something or work on something, that he needs to get a specific order from the court to not run afoul of the terms of the order. So I know we had that discussion previously, and if anything, I'm wondering if I need to potentially clarify the order to make it a little less restrictive to allow Mr. Archibald to proceed without worrying that he's going to violate the order by doing his job. So your thoughts on that, Ms. Blake?
Your Honor, the state has no objection to that. The state's recollection was when we had the hearing at Mr. Pryor's request that the order was actually modified on the record. I thought that Mr. Pryor had followed it up with a written order indicating such, but I think we had a similar discussion on the record regarding the potential to discuss it with certain defense witnesses or experts or staff, and the court did relieve or modify the protective order with regard to Mr. Pryor and the state at that time. I don't recall that Mr. Means made argument on that motion. He may have, but if so, I do not recall that. But either way, the state does not have an objection to modifying that protective order to allow Mr. Archibald to speak with staff experts who he needs to regarding the case. And obviously, specifically with regard to his client, he should be able to go over discovery with her. And I don't think the state ever had an intent for the order to restrict that counsel's ability to discuss the case or discovery with their client. So if the court needs any additional information or clarification, the state's happy to provide that.
Okay, thank you for that. I looked back through Mr. Daybell's case and did not see where we actually entered a modified order. So perhaps that's a matter of housekeeping I need to take up in both cases. But Mr. Archibald, so I think the order should be modified to the extent that it doesn't cause you concerns when you're working with staff and others that need to have necessary access to this information. So based on all that, I'll grant that part of the state's motion, but actually I think I will go back in and issue an amended order that will be effective in both cases. I'll notify Mr. Pryor of that so it doesn't come as a surprise. We've already had that discussion with him, but based on the findings of this hearing, I think it's appropriate that we clarify those orders, make sure they allow the defense counsel to have adequate access to people necessary that are assisting them in the case.
Very good. Thank you, Your Honor.
Okay, and then that would apply as well to the state using their resources as well in prosecution of the case. So I will work on getting a redraft of the protective order issued in both this case and Mr. Daybell's case, and we'll submit those into the case and serve those on counsel. All right, is there anything else we need to take up on the hearing today then from the state?
Not from the state, Your Honor. Thank you.
All right, thank you, Ms. Blake. Mr. Archibald, anything further for the defense?
No, Your Honor. Thank you.
All right, thanks for your attendance, everyone. We'll be in recess.
Okay, so there you go. End of the hearing. So no news if Lori Vallow is going to get another lawyer. No news regarding her. Sorry, you guys, I'm just readjusting my desk here. Nothing regarding her mental state. Yeah, so the prosecution didn't get what they wanted. To me, when I read over their motion, it almost sounded like they wanted a gag order. That's what it sounded like, even her speaking to the judge here. To me, it sounded also like they were asking for a gag order. So the judge wasn't going to give that. A gag order would stop not only Mark Means from discussing anything, it would also stop anything getting out to the public, which is only done in very rare cases. So what we do know is there's going to be a new draft done regarding information, and they got to release some stuff that is under seal right now from the grand jury and release that to Mr. Archibald because he does not have a copy of it. From what I just understood is even Lori doesn't have a copy of the grand jury report. So, and its findings. So I'm sure that they will be going over that. Now, the only thing that I was hoping to find out is if all of a sudden Lori miraculously became competent, because she's going to, I believe she is going to fight. She wants Mark Means on this case. Okay, so Summer says, okay, I have one more question. She has a right to hire the lawyer of her choice and he moved. I wonder if something happened behind the scenes. I don't know, but the thing is, she can't even fight this right now because she's not competent. The law states that you were entitled to have the lawyer of your choice. Okay, so that is something she could fight if she wanted to. Okay, but she can't fight it. She can't even file a motion to fight it because she's incompetent. So I was half expecting for her to miraculously come back to competency so she could fight having Mark Means thrown off her case. Sorry, you guys, that was my phone. Yeah, so she says. Snowglow says, why does she want Mark Means? I think secretly that could have maybe been her sixth husband if things had gone according to her plan, because I really do feel there was a lot of flirting going on, at least from her side. And Mark Means kind of stuck his neck out pretty far for her, above and beyond legal things that he should have been doing. So I don't know if something was going on there. I don't know if Mark Means and his wife have split, but I do know that Mark Means has sold his home and moved out of Idaho. He is now in Missouri. So now, if she does fight and get him back on the case, I don't know what he's going to do. Yeah, he's he seems like a pretty weak individual. Summer, I really don't know what there is to read on. We don't know, Sammy, why he moved. No idea. Maybe to save face. I do think that he's going to be disbarred. No, she's indigent, so she can still choose any lawyer of her choosing, and the state would have to pay for it. Yeah, Jim Archibald is the one that you just seen. He was added to the case along with Mark Means when they handed down, when the prosecution came in and said that they'd be seeking the death penalty, because neither Mark Means or John Pryor are death penalty case certified. So they each got a court-appointed death certified attorney to work alongside of the attorneys already in place, which would be Mark Means and John Pryor. But Mark Means has now been removed. He was removed by the court, but Lori can fight that. But she has to be competent to fight that, right? No problem, Snowglow. So, I mean, she doesn't have no $1 million body now that there's no Botox and her hair can't be dyed and stuff like that. She hasn't got the $1 million body now. The last photos that we've seen of her, she looked probably 10 years older than what she was. Yes, he could refuse if that was the case, but I don't think he would. The worst that could have happened there is there would have been reason for a retrial or something along those lines. Mark Means is now a translated being. He found enlightenment in a portal through Lori. Thank you, Cindy, for staying on top of that. He's not disqualified so far. Where did I just see that? No, Susan, the courts, if you don't have the money, indigent, then the court pays for your lawyer. Now, where did I just see that? He's been disqualified by the court. He's not a disqualified lawyer yet. The only one that can take away his right to practice is here we have the Upper Canada Law Society, but I do think that he could be disbarred over the perjury and everything that he did. But don't forget, you can represent yourself with no legal background at all. So she can choose anybody she wants to come in and represent her, which could be Mark Means. She could fight this if she wants to, but she'd have to be competent. Yes, he could be facing criminal charges out if he's disbarred. She is facing the death penalty. The charges that she's facing right now, they are asking for the death penalty. She hasn't even entered a guilty or not. She hasn't even gone for advisement yet because right away, boom, I'm mentally ill. So she hasn't been arraigned or anything yet, but it is already in her record that they are going for the death penalty. Okay, so there you go. Courtney says he bought a house in Troy, Missouri, outside of St. Louis. Yeah, from what I hear, she's not looking too good. It's been more than 6 months that she's in there now. Yes, Lori does know. She watches all of the hearings from her jail cell. Or at least from the jail. No problem, Cindy. Thank you for being here. I'm going to wrap up soon anyway. Yes, she can still fight. It depends on, number one, it's going to depend on if he's disbarred or not. If he's been disbarred, then I don't know what's going to happen there. But I know here you can still have anybody represent you want, whether they're a disbarred lawyer or not. I don't know how it works in the US, but I know here you can. You can have anybody you want represent you as long as you have a qualified lawyer that sits as first chair. Now, can Lori still retrain Mark? Means she can fight it if he's living out of state. If he's not disbarred, he may still hold an Idaho license. If not, he would just have to regain his Idaho license to practice. Yeah, she could always take a plea. We don't know. Lori and Chad might have something on Mark. Anything's possible. Capel says that's what she's... A great place for Lori to be going through menopause. Summer says, man, I can't help but see her and Mark plotting this whole mess, and she has them hook, line, and sinker, yeah. You're very welcome, Janice. I do believe that Chad has already turned on Lori. And I believe that both, I think the initial plan was they were going to blame Alex. But then they seen all the evidence that the prosecution has against them. There's just no way you can talk your way out of the evidence that they have. I believe they were first going to try and blame it on Alex, but now I do believe, and hey, go back to when when this first started happening, before Lori and everything was arrested. Even once Lori was arrested for just not producing the kids, I said, they're both going to end up being arrested. You go back and watch some of my reads that I did way back then. The very first ones, I said they will both be arrested and they will turn on each other. Okay, so like I said, I don't know what the laws are in the US, but I know here you can have anybody you want represent you, even if it's disbarred lawyer. No, I don't think they're offering a plea deal. Chris H says, I'm 15 minutes from Troy, Missouri. Are you sure? I know several lawyers there. Apparently that's where he is. Somebody in chat had said that that's where he is. I know he went to Missouri, but I don't know exactly where, but somebody did say Troy, Missouri. No, Jazzy Mum. It's okay, Summer. Oh, I don't think anybody has to talk him into it. Now that they've seen all the evidence, I believe that they're going to be pointing the fingers at each other. And that's why John Pryor now wants the cases severed. John Pryor is hoping that Lori does not come back to competency until Chad's trial is over. But Chad's trial is not scheduled to start until 2023, I believe. Or is it March of 2022? I think it's... I'm just looking here, you guys. I know Letitia Stout's trial starts in March. Looking down the line here, you guys. Barry Morphew start in May, unless something goes wrong there. No, I believe that they are in March of 2023. Chad and Lori's trial is supposed to start in March of 2023. Barry Morphew is supposed to be going to trial the beginning of May of this year, but that may change now that they have to find a new judge because Judge Murphy was thrown off the case. So that may change. Letitia Stout, as far as I know, is still a go. Her pretrial starts March 17th, and then her trial starts March 28th. Okay, so here we go. So Lisa Culver says in the U.S., the answer is no. A disbarred attorney cannot represent anyone in court. That may happen, Georgia. It may. There you go, you guys. Excuse me. Like I said, there are some laws that are different here in Canada than in the US. Right? Stay-at-home mom detective says, I hope she is deemed competent like we all suspect. I know she's competent. Now that Mark isn't there to cover her plan, I hope she's does some stuff up. The prosecution plan will work. Yes. I'm hoping that it is streamed. You can guarantee it that the media is going to be asking for a pool camera. I'm sure you guys all know what a pool camera is. No, Canada does not have a death penalty in any province. Right across Canada, there is no death penalty. The worst that you can get is a life sentence, which is 25 years. The only thing worse than getting the 25-year sentence is okay. Just a second, you guys. Okay, yeah, thanks. Sorry about that, you guys. Yeah, we have something under another act that if you are found to be a repeat offender, they can hold you indefinitely. But we don't have the death penalty. Alander says she constantly covered up her crimes. If she were insane, she would justify her actions. Hello, Mary. Okay, you guys, so that's it. I'm going to let you guys all get back to what you need to be doing. It's going on 6 p.m. here. So I am going to get going so I can make something for dinner. But there you have it. I will keep an eye out for the Barry Morphew, on the Barry Morphew case, to see what is happening there since Judge Murphy was removed from his case. I'll keep an eye out and see when that is going to be heard next. Hopefully his court date is not changed from this coming May. Letitia Stout is supposed to be starting in March of this year. So let's hope that those two trials do stay on track. If there's anything else that comes out, you guys, I will be sure to jump on here and let you guys know. Okay, so thank you for joining in. Thank you for watching along with me. Until the next time, love you guys to the moon and back. Thank you for my mods being here. Thank you to each one of you guys for being here and supporting the channel. Till next time, please take care of yourselves. Please stay safe. Love you to the moon and back. Bye-bye for now.